Interpretation of statutes. Interpretation is the process by which the courts determine the meaning of a statutory provision for the purpose of applying it to a situation before them. Next definition. By interpretation or construction is meant the process by which courts seek to ascertain the meaning of legislature through the medium of authoritative forms in which it is expressed. This definition is by Salmond. In common usage, interpretation and construction are usually understood as having the same significance. Statutory interpretation is the process of interpreting and applying legislation to decide cases. Interpretation is necessary when the case involves a subtle or ambiguous aspects of a statute. Generally, the words of a statute have a plain and straightforward meaning. But in some cases, there may be ambiguity or vagueness in the words of the statute that must be resolved by the judge. Need for interpretation of a statute. The object of interpretation of a statute is to determine the intention of the legislature conveyed expressly or impliedly in the language used. The essence of law lies in the spirit, not its letter, for the letter is significant only as being the external manifestation of the intention that underlies it. So says Salmond. The reason for ambiguity or vagueness of legislation is the fundamental nature of language. It is not always possible to precisely transform the intention of the legislature into written words. Interpreting a statute to determine whether it applies to a given set of facts often boils down to analyzing whether a single word or a short phrase covers some element of the factual situation before the judge. The expansiveness of language necessarily means that there will often be equally good or equally unconvincing arguments for two competing interpretations. A judge is then forced to resort to documentation of legislative intent, which may also be unhelpful, and then finally to his or her own judgment of what outcome is ultimately fair and logical under the totality of circumstances. Gray sums up the views as thus: the state exists for the protection and forwarding of human interests mainly through the medium of rights and duties. If every member of the state knew perfectly his own rights and duties, and the rights and duties of everybody else, the state would need no judicial organs. Administrative organs would suffice. But there is no such universal knowledge. To determine in actual life what are the state's and citizens' rights and duties, the state needs and establishes judicial organs, the judges. To determine rights and duties, the judges settle what facts exist and also lay down rules according to which they decide the legal consequences from facts. These rules are called law. To find the meaning of statutes, judges use various tools and methods of statutory interpretation, including traditional canons of statutory interpretation, legislative history, and purpose. In common law jurisdictions, the judiciary may apply rules of statutory interpretation to legislation enacted by the legislature or to delegated legislation such as administrative regulations. Interpretation of statutes is done by the judiciary in order to avoid 1. Uncertainty, 2. Friction, 3. Hardship, 4. Inconvenience, 5. Injustice, 6. Absurdity, 7. Anomaly, 8. Inconsistency, and 9. Repugnancy that might result in the absence of certainty, clarity, consistency, and brevity with regard to a particular statute or a statutory provision. Interpretation is as old as language. Elaborate rules of interpretation were evolved even at a very early stage of Hindu civilization and culture. The importance of avoiding literal interpretation was also stressed in various ancient textbooks. Merely following the texts of the law, decisions are not to be rendered, for if such decisions are wanting in equity, a gross failure of dharma is caused. Interpretation thus is a familiar process of considerable significance. In relation to statute law, interpretation is of importance because of the inherent nature of legislation as a source of law. The process of statute making and the process of interpretation of statutes are two distinct activities. In the process of interpretation, several aids are used. They may be statutory or non-statutory. Statutory aids may be illustrated in General Clauses Act 1897 and by specific definitions contained in individual acts, whereas non-statutory aids is illustrated by common law rules of interpretation, including certain presumptions relating to interpretation, and also by case law relating to interpretation of statutes. Lord Denning in Seaford Court Estates versus Asher English knowledge is not an instrument of mathematical precision. It would certainly save the judges from the trouble if the Acts of Parliament were drafted with divine precision and perfect clarity. In the absence of it, when a defect appears, a judge cannot simply fold hands and blame the draftsman. It is not within the human powers to foresee the manifold permutations and combinations that may arise in actual implementation of the Act, and also to provide for each one of them in terms free from all ambiguities. Hence, interpretation of statutes becomes an ongoing exercise as numerous facts and conditions continue to arise. Next heading, chapter Law Making. The process of passage of a bill includes several stages. First is draft, then public feedback invited, then cabinet approval, then introduced in one house, then referred to the standing committee, then consideration of the bill, then clause by clause discussion and voting, then voting in the other house, then presidential assent, then rights and regulations formed. Legislative, executive, and judiciary, three organs of the state. The process of lawmaking in relation to Parliament may be defined as the process by which a legislative proposal brought before it and then is translated into law of the land. It can broadly be divided into three stages. One, pre-legislative phase, second, legislative phase, third, post-legislative phase. When a bill is in its draft stage, it may be placed in the public domain for the stakeholder feedback. Over the years, a few draft bills have been published for stakeholder information and feedback. Pre-legislative phase comprises identification of a need for a new law or an amendment to an existing legislation, drafting of the proposed law, seeking inputs or comments from different ministries and public, revision of the draft bill to incorporate such inputs, and getting the same vetted by the law ministry. It is then presented to the cabinet for approval. The government has issued a pre-legislative consultancy policy to ensure efficient pre-legislative scrutiny of a legislative proposal in consultation with the stakeholders. It includes publishing or placing in public domain the draft legislation, or at least the information that may inter alia include brief justification for such legislation, essential elements of the proposed legislation, its broad financial implications, and an estimated assessment of the impact of such legislation on the environment, fundamental rights, lives, and livelihoods of concerned affected people. An explanatory note explaining the key legal provisions of the draft legislation or rules in simple language. Summary of feedback or comments received from the public and other stakeholders. In addition, the department or ministry concerned is also required to include a brief summary of the feedback received from stakeholders, including government departments and the public, along with its response in the note for the cabinet along with the draft legislation. The summary of pre-legislative process is also required to be placed before the department related parliamentary standing committee by the department ministry concerned when the proposed legislation is brought to the parliament and is referred to the standing committee. After the cabinet approves the bill, it is introduced in parliament. On introduction of the bill, the minister of the concerned department may send notice demonstrating the intention that the bill may be moved, considered and passed. He be referred to the select committee of the house or joint committee of both houses, or for eliciting public opinion. Once the bill is taken for consideration, perusal must be made on a clause-to-clause basis, and the same may be accepted, amended, or rejected. Subsequently, the House votes on the bill with amendments, if any. If the bill is passed in one House, it is then sent to the other House. In the case of a deadlock between the two Houses, or in a case where more than 6 months elapse in the other House, the President may summon, though he is not bound to, a joint session of the two Houses, which is presided over by the Speaker of the Lok Sabha, and the deadlock is resolved by a simple majority. Once the bill is passed by both the Houses, a copy of the bill is sent to Legislative Department of Ministry of Law and Justice for scrutiny. Post scrutiny by the Ministry of Law and Justice, it is presented to the President for assent. The President has the other right to seek information and clarification about the bill and may also return it to Parliament for reconsideration. After the President gives his assent, the bill is notified as an act. Subsequently, the bill brought into force and the rules and regulations to implement the act are framed by the concerned ministry. The same are then tabled in Parliament. It is good to remember that the President can refer back to Parliament only once. If the Parliament again passes the bill in the same form and sends it back to him, President no option but to sign the bill. Principle of utility. Bentham's book, The Theory of Legislation, is a masterpiece in the field of law. Bentham's objective is to educate the legislators and to provide them with sound philosophy broad based on the theory of utilitarianism. Legislation is a science and an art. It is a science as it contains certain basic principles to do good to the community. It is an art when it provides for the various means to achieve that good. The objective of the legislator must be to do public good. He may base his reasons on general utility. Utility is the basis of Bentham's theory. The principles of utility form the basis of his reasoning. On an analysis of the principles of utility, we find that all our ideas, judgments, and determinations spring from certain motives, pleasure and pain. It is the duty of the moralists and the legislators to make a great study of these two concepts, pleasure and pain. Utility is an abstract term. It expresses some propensity or a tendency of a thing to prevent some evil or to do some good. Evil is the pain and the cause of pain. Good is the pleasure and the cause of pleasure. Hence, anything which conforms to this utility brings happiness to the individual. The legislator must have the objective to augment the total sum of happiness of individuals that form the community. Utility is the first principle, the first link in the chain. The legislator's reasoning for making a particular law must be based on this principle. Utility has a commendable logic behind it. In making the law, legislator must calculate or compare the pleasure or the pain that it brings about. Here, pleasure and the pain are used in ordinary meaning, that is, what everybody feels. When put in situation, it is the experience of the pleasant and the prince, the unlearned and the philosopher. Utility as a principle has its essence in the virtue and the vice. Virtue is as good as it brings pleasure. Vice is as bad as it brings evil. Moral good is good as it brings pleasure to the man. Moral evil is bad as it brings pain to the man. The legislator who believes in the theory of utility finds in the process of lawmaking a number of these virtues and evils that the proposed law may bring about. His objective must be to bring more virtue. He must also distinguish between pretended virtues and evils from the real virtues and evils. These are the facets of the concept of utility, and based on this exposition, Bentham develops his theory of utilitarianism. He works the theory of legislation and introduction to the principles of morals and legislation form a manual of instruction to a legislator. A knowledge of these makes a legislator appreciate the moral and legal philosophies of Bentham, and also to get an insight into the sociology of law. Law and Public Opinion heading. Public opinion is considered to be the essential element for successful working of democratic communication in the system. Public opinion is the expression of the views of citizens. No government can afford to ignore it. A sound and effective public opinion can even shake the structures of dictators. The strength of democratic system lies in respecting the mind power of the people. There should be free and fair interaction of thoughts for solving the collective problems. Public opinion acquires great relevance in realizing this democratic goal. It promotes wider awareness and invites citizens to examine issues from different points of view. The significance and role of public opinion can be explained as follows. A. Guide to the government. Public opinion acts as a guide to the government in respect of policy formation. Government functions in general on the basis of mandate received in elections and tries to win over the masses to fulfill the promises made during elections. Helping in law making. Government is always under pressure of public opinion and take note of the same in formulating laws for the common good. Governmental policies are invariably affected by people's opinion on various issues. Public opinion helps the government to enact laws in general situations. Acts as a watchdog. Public opinion acts as a watchdog. It controls and checks the government from becoming irresponsible. While criticizing the wrong policies of the government, public opinion always keeps the government alert. Government is always conscious of the fact that people would not vote for it and bring it back to power again if it goes against the wishes of the people. Next, protect the rights and liberties. Public opinion acts as the protector of rights and liberties of citizens. In a democratic country, people have the right to criticize or support the government in their own way. More effective and positive use of this right not only encourages or motivates the government, but also keeps the government alive towards the rights and liberties of people. Next, acts as a powerful force in international sphere. Public opinion has acquired worldwide importance. In fact, international relations are influenced by public opinion. In the age of globalization, issues like promotion and protection of human rights, environment and discrimination based on race, religion or sex, prevention of child labor, terrorism, hold international community answerable to the public opinion. Therefore, the governments remain conscious of such international public opinion also. In fact, no democratic government can afford to ignore public opinion. The manner in which policy or legislations are drafted is often questioned by both experts as well as those who practice. The law-making process in India in general includes certain aspects of impact assessment. such as inviting public comments on draft legislation, consultation with relevant stakeholders, and study of social and financial costs and benefits. However, it seems that the requirement is often not complied with as it is not mandatory, and the process has led to certain ambiguities. While the Manual on Parliamentary Procedures in India, that is the manual, does not mandate any stakeholder consultation per se, but the Pre-Legislative Consultancy Policy (PALCP) requires undertaking stakeholder consultations. Yet, neither the manual nor the PCLP describe the process of conducting these stakeholder consultations and the manner in which all interested parties would need to be represented. Lack of availability of information in public domain acted as one of the challenges in determination of the quality of public consultation under legislations under consideration. The manual and PCLP mandate the concerned department to invite public comments on draft legislation, but there are no specific provisions that mandate the relevant department concerned for providing rationale as to acceptance or non-acceptance of any recommendations. A mechanism of feedback to the stakeholders in terms of providing rationale is important to ensure transparency and also to ensure a sense of ownership on part of the stakeholders towards draft legislation. Cabinet note is part of the office memorandum that explains objective behind the draft legislation. However, it is not public document, making it difficult for the stakeholders to ascertain the rationale and objective behind the legislation. The manual mandates that the bill needs to be referred to a related standing committee. The manual is the principal document for ascertaining law-making process in India that exhaustively explains the process. However, PCLP has an overriding effect over the manual to the extent of pre-legislative process, and it is difficult to ascertain at this juncture at which provisions under PCLP will be read along with the manual. Norman Luthbeck outlines the theoretical basis of the political linkage between public and policy makers in two broad groups: coercive models and non-coercive models. In a coercive model, the public applies pressure, either real or potential electoral pressure, to force the lawmakers to enact the desired policies. Luthbeck defines these models as rational activist model. Public exerts pressure electorally. Representatives must enact policy demands of the public, or the public will elect someone else who will enact those policies. Political parties model. The political parties act as an intermediary between the public and representative. Public holds the party responsible for the policies to be enacted, and the parties therefore exert pressure on the lawmakers to follow the party line or to enact policies for the good of the party. Pressure group model. In this model, the public expresses itself to lawmakers by gathering in groups, business groups, labor unions, or interest groups. These groups influence lawmakers through money or electorally to support the policy of the group. These pressure groups have more influence than individuals. It is not necessary for the public to coerce public officials to do their will. Non-coercive models explain how public policy can reflect public opinion without a direct threat to the policy maker. The two non-coercive models offered by Luthbeck are belief sharing model. In this model, policymakers are not acting to heed the desires of the electorate, but are acting on their own belief. However, the lawmaker was elected because the lawmaker shares the same beliefs as his constituency. This model reflects the theory of some political scientists who maintain that elections are about the candidate's values and not about issues, which would be the rational actor model. Next, role-playing model. In this model, representatives act as their constituency's delegate. Lawmakers respond to policy decisions by anticipating the desire of the district. This is differentiated from the rational actor model because the lawmaker is not responding from pressure by the public, but is proactively producing policy that his representative believes his or her constituency desires. Next heading, Law and Social Control. Relevance of John Rawls and Robert Nozick. Rawls, born 1921, holder of the chair in philosophy at Harvard, produced in 1971 A Theory of Justice, which called for a new look at the principles of social justice. Nozick, 1938 born, who had studied under Rawls and who also held a chair in philosophy at Harvard, produced in 1974 Anarchy, State and Utopia, a plea for social libertarianism, based upon the entirely different approach to that taken by Rawls. Both works aroused considerable interest. Both exemplify important facets of the continuing concerns of contemporary American jurisprudence. Rawls' theory is based upon three elements: a vision of society as it ought to be, a view of moral theory and its significance, and the derivation of principles which will enable the expression of that vision to be enunciated so as to reflect the moral theory. He assumes a society whose members wish to decide a set of principles from which to construct a pattern of social justice. Their principal objective is the building of a well-ordered society which will advance the good of its members in accordance with the public concept of law. Rawls suggests the initiation of a hypothetical congress of persons who are to choose, as a result of the discussion and agreement, the fundamental principles which will guide their society. In this original position, persons will select principles which will not take into account any particular interest. They are to define principles which are objectively just. Nozick is concerned to emphasize individual rights within society and as to how political obligation is derived ultimately. From the Indians have the right in property, for example, which exists independently of social and legal institutions within society. These rights must not be interfered with by the state. Indeed, where a state enforces such rights, it is merely doing for individuals what they are already entitled to do on their own behalf. Concepts of liberty and equality are incompatible with each other, so that any attempt by the state through its legal administrative organs to interfere with the pattern of resource distribution within society is to be considered as violation of rights. In that it necessitates interference with individual liberty. John Rawls, A Theory of Justice. Rawls presents an account of justice in the form of two principles, liberty principle and equal basic principle, such as freedom of speech, freedom of conscience, and right to vote should be maximized, and difference between inequalities in social and economic goods are acceptable only if they promote the welfare of the least advantaged members of society. Rawls writes in the social contract tradition. He seeks to define equilibrium points that, when accumulated, form a civil system characterized by what he calls as justice as fairness. To get there, he deploys the argument whereby people in an original position, state of nature, make decisions or legislative laws behind a veil of ignorance of their place in society, rich or poor, using a reasoning technique he called as reflective equilibrium. It goes something like, behind the veil of ignorance, with no knowledge of their own places in worship, Rawls posits that reasonable people will default to scientific and economic positions that will maximize the prospects for the worst off feed and house the poor in case you happen to become one. It's much like the prisoner's dilemma in the game theory. By his own reflections, Rawls says it is left liberalism. Robert Nozick, Anarchy, State and Utopia. Libertarian response to Rawls, which argues that only a minimal state devoted to the enforcement of contracts and protecting people against crimes like assault, robbery, fraud can be morally justified. Nozick suggests that the fundamental question of political philosophy is not how government should be organized, but whether there should be any state at all. He is close to John Locke in that program is legitimate only to the extent or degree, and then it promotes greater security for life. Liberty and property, as there would exist in a chaotic pre-political state of nature. Nozick concludes, however, that the need for security justifies only a minimal or night watchman state, which it cannot be demonstrated the citizens will attain any more security through extensive governmental intervention. The state, which may not use its coercive apparatus for the purpose of getting some citizens to aid others, or in order to prohibit activities to the people for their own good or protection. Next heading. The primary difference between two is the treatment of legitimacy of the Gordon distribution of wealth. In the place of Rawls' difference principle, Nozick espouses the entitlement theory of justice, according to which individual holdings of various socio-economic goods are justified only if they are derived from just acquisition or voluntary transfer in safety nets, allowed acquisition from social program, are not just because they are funded through the involuntary transfer of wealth via taxation and are therefore taboo. No, accumulation for free riders should be made. Most problem, Nozick never spells the criteria for just acquisition. Nozick requires Rawls' rationale for his defense principle. It is implausible to claim that merely because all members of a society benefit from social cooperation, the less advantaged ones are automatically entitled to a share in earnings of their more useful ones, peers. Similarities. Both theories jump off with a sweeping statement of the primacy of justice. Nozick more or less retained Rawls' first principle of liberty, while rejecting the second difference. But regarding the governmental redistribution of wealth, Nozick seems to admit that his entitlement theory is insufficient to refute demands for redistributionist ones. Surely some collective holdings were acquired via some original act of unjust conquest, right? In response to, Nozick agrees that a Rawls-like difference approach is morally acceptable after all, what he terms as rectification, on the premise that those currently least well off least well off have the highest probability of being descended from previous victims of injustice. Both shared a view of political philosophy as an exercise in production of abstract theories, with little regard to the practical grounding of justice in human nature, that is, of conformity with likely demands of actual human beings. Therefore, both theories rate a society's success by how closely its laws and procedures adhere to the model rather than whether those laws produce morally maximized outcomes. Both clearly followed Immanuel Kant's decision, let justice triumph, even if the world perishes by it. Laws and morals heading. According to Bentham, legislation has the same center but it has not the same circumference. Morality is an art, it directs the acting of men to produce the greatest possible sum of greatest good. The objective of the legislature must be the same, though these two differ in their extent. Still, the end is the same. All actions, public or private, come within morality, and individuals are guided by it throughout their lives. However, legislation cannot do this. The reasons. 1. Legislation can have no direct influence over individuals except by punishment. Second, there is the possibility of punishing the innocent in the anxiety of punishing the culprits. Hence, Bentham vertically divides the area of legislation, suggests legislators not to interfere with personal interest of the individual. The reason is the person himself is the best judge and he will correct himself when he finds he is in the wrong. Example, temperance. The legislator must look to those areas when a person's conditions create evil on others and to legislate there. Then punishment will be effective, meaning, objectives and scope of interpretation, construction and statute. The expression interpretation and construction are used interchangeably. Bayesian terms the distinction is trivial because according to him there is no material distinction between the two. Interpretation cannot denote more than construction does, and the idea of determining the legal meaning of any enactment. Construction is more concerned with extracting the grammatical meaning. A statute is an edict of the legislature. Interpretation is the journey of discovery. It is the process of ascertaining the meaning of an act of parliament from a provision of an act. Public opinion and lawmaking. In 2006, the Select Committee on Modernization of House of Commons said parliamentary scrutiny at the pre-legislative stage can play an important role in improving the law, even where there have already been lengthy and extensive external consultations by the government. Whatever its impact on the passage of legislation, the purpose of pre-legislative scrutiny is not to secure as easy right for a government legislative program. It is to make better laws for improving the scrutiny of bills and drawing the wider public more effectively into the parliamentary process. At present, government departments in India are not obliged to either publish draft bills or elicit public opinion on specific pieces of legislation. At the central and state government levels, laws are drafted by the concerned ministries, often in consultation with one or more ministries. The procedure for formulation and drafting of legislation is spelled out in the Manual of Parliamentary Procedures. While the department advises departments to formulate legislative proposals in consultation with all the interests and authorities concerned essentially from the administrative and financial point of view. There is no specific reference to constituents consulting the public or seeking their views at the pre-legislative stage. Once a draft bill has been formulated by the concerned ministry, it is circulated to other ministries for inputs. The comments received are incorporated, then the draft bill is sent to the Law Ministry for vetting and finally submitted to Cabinet for approval. After receiving Cabinet approval, the bill is finally presented to Parliament. In some cases, draft bills may be referred to further review to one of the 24 parliamentary standing committees, 16 Lok Sabha, 8 Rajya Sabha. During the review process, such committees typically issue advertisements in newspapers seeking comments from public. In many instances, stakeholders are invited to give oral and written submissions stating their view. However, the government is not obliged to accept the recommendations made by the standing committee. There are some other exceptions. During the drafting of the Right to Information Act, for instance, the Parliamentary Standing Committee reviewing the bill received a number of submissions from civil society groups seeking improvements in the new draft RTI law. Many of these suggestions were later incorporated into the final text of the RTI Act 2005. While standing committees do provide an opportunity for citizens to voice their opinion, this form of consultation has severe limitations. First, draft bills are referred to the standing committee after their introduction in Parliament. This limits the scope of citizen influence. Moreover, committees are not obliged to take on board the legislation and inputs they receive. Second, the proceedings of the Parliamentary Standing Committee are closed, and the media are barred from reporting the details of consultation. Thus, public debate on bills is limited. Last, there is a little transparency, as such committees rarely, if ever, publish details of the comments and suggestions received by them. The lack of transparency and public consultation in the drafting of legislation has in recent times been a subject of intense criticism. For instance, amidst controversy, the civil liability of the nuclear damage bill, a noted journalist criticized the government for trying to push through a complex legislation with the potential to affect the lives of tens of millions of people with stealth subterfuge and barest minimum consultation. Similarly, bills such as Prevention of Corruption Act, a Prevention of Torture Bill, and the Communal Violence Bill, Biotechnology Regulatory Authority Bill have been critiqued for their poor drafting, weak provisions, and their failure to address the concerns of civil society groups and other stakeholders. Internationally, in many countries, pre-legislative scrutiny is an established process through which citizens are encouraged to give their comments and feedback on the proposed legislation. Despite the lack of formal channels of pre-legislative scrutiny in India, there are a number of ways in which legislative process can be made more open and participatory. Next, adding public consultation as discussion and approach papers. In many countries, the government departments formulate exploratory green paper or discussion papers that spell out the policy objectives of the government on a specific issue. These papers are intended to stimulate public debate and discussion. Green papers are usually followed by white paper, which sets out the concrete steps necessary to translate idea into action. In India, a growing number of ministries have begun to formulate discussion papers that seek public input on specific policy issues. In October 2010, Department of Personnel and Training released a discussion paper on data protection and privacy law in India for public comment. Discussion paper was drafted following a series of meetings between government officials, civil societies, and other stakeholders. More recently, Planning Commission has sought inputs from public in drafting the approach paper to the 12th five-year plan. The approach paper spells out the major priorities and targets for the government, key challenges in achieving them, and the broad policy approach of the government. Another good example of the ministry taking the lead in consulting with the public is the Department of Industrial Policy and Promotion. Over the last year, the department has released a series of decision papers on its website seeking views and suggestions on whether foreign direct investment should be allowed into professional service firms. Through these papers can be department hopes to generate informed discussion on the subject so as to enable the government to take an appropriate policy decision at appropriate time. In what is clearly the best practice, the department has also taken the proactive step of publishing scanned copies of submissions received from public on its website. Publishing draft legislation. In some cases, have also begun to publish draft bills and amendments to rules and regulations before they are tabled in Parliament. This enables citizens to send in their comments at an early stage in the legislative process and by associates allows the government to take on broad different views and perspectives. A fine example of this has been the extensive consultation around the draft Direct Taxes Code. In 2009, the Ministry of Finance launched a public consultation on the draft Direct Tax Code scheduled to replace Income Tax Act. As a part of the consultation process, Ministry released a draft of the bill and discussion paper for public comment. On the basis of submissions received by the Ministry, then released a revised discussion paper. The RTA Act 2005 is another example where the government has taken proactive step of seeking public opinion on proposed legislation. In December 2010, Department of Personnel and Training announced its proposal to amend the rules governing RTA Act 2005. The department published the proposed amendments on its website and invited public to send in comments by specific date. Operationalizing Section 4 of the RTA Act. Right to Information Act, in addition to placing a legal obligation on the government to provide information for the first time, places an obligation on government department to proactively and publish information while formulating policies. Specifically, Section 4(1) of the RTA Act requires every public authority to publish all relevant facts while formulating important policies or announcing the decision which affect the public. In this way, the Act for the first time ever places a legal obligation on department to publish draft policies. This has been confirmed by the Central Information Commission, which recently ruled that Section 4(1) of the RTA Act requires proactive disclosure of the proposed laws and policies and amendments thereto the existing laws and policies to enable citizens to debate in the informed manner and provide useful feedback to the government, which may be taken into account before finalizing such laws or policies. CIC's decision follows from a complaint filed by Venkatesh Nayak against the non-disclosure of the draft Delhi Police Amendment Bill 2012 by the Delhi government. In another decision relating to non-disclosure of the draft text of the whistleblower bill, CIC has recommended that the Cabinet Secretariat send its administrative rules to allow for greater public consultation on the draft legislation. A number of ministries are now proactively taking steps to engage with the public and seek Comments and inputs on the draft laws. While there is no formal requirement for pre-legislative scrutiny within the legislative process, there are ways in which the lawmaking process can be made more participatory and open. Exploratory green and discussion paper enables the government department to frame key policy issues and concerns to put those out for public debate and comment. Proactive disclosure of the draft bills on government websites for public comment is another way in which the public can be informed on the government's proposals. Next chapter is Nature and Kinds of Indian Laws. We'll do it later. Nature and Kinds of Indian Laws. A statute is a formal written enactment of a legislative authority that governs a country, state, city, or a country. Typically, statutes command or prohibit something or declare a policy. The word is often used to distinguish laws made by legislative bodies from the judicial decisions of the common law and the regulations issued by the government agencies. Black Law Dictionary. A statute is a will of legislature conveyed in the form of text. The Constitution of India does not use the term statute, but it uses the term law. Law includes any ordinance, order, bylaw, rule, regulation, notification, custom, or usage having the force of law. Article 13, Clause 3, Clause A of the Constitution. An Indian statute is an act of the central or state legislature. Statutes include acts passed by the imperial or provincial legislature in pre-independence days, as well as regulations. Statutes generally refer to the laws and regulations of every sort, every provision of law which permits or prohibits anything. Statutes are commonly divided into following classes. 1. Codifying statute, when they codify the unwritten law on a subject. Next, declaratory statutes, when they do not profess to make any alteration to the existing law, but merely declare and explain what it is, make it obvious and make it official. Remedial law, when they alter the common law or the judge-made non-statutory law. Amending law, when they alter the statute law. Consolidating law, when they consolidate several previous statutes relating to the same subject matter with or without alterations of substance. Enabling law, when they remove a restriction or a disability. Disabling law or restraining law, when they restrain the alienation of property, etc. Penal or imperative law, when they impose a penalty or forfeiture. A type of mandatory statute is an imperative statute. Imperative statutes are often negative or prohibitory in its terms and make certain acts or omissions absolutely necessary and subjects the contravention of its provision to a penalty. When the statute is passed for the purpose of enabling something to be done and prescribes the formalities which are to attend its performance, those prescribed formalities which are essential to the validity of the things which are done are called imperative or absolute. But those which are not essential or may be disregarded without invalidating the things to be done are called dilatory statutes. Imperative statutes must be strictly observed. Dilatory statute may be substantially complied with. A statute may generally be classified with reference to its duration, nature or operation, object and extent of application. Classification on the basis of duration. Perpetual statutes. It is perpetual when no time is fixed for its duration and such a statute remains in force until its repeal, which may be expressed or implied. Temporary statute. A statute is temporary when its duration is only for a specified time and it expires on the expiry of a specified time unless it is repealed earlier. Classification on the basis of nature of operation. Prospective statute. A statute which operates upon acts and transactions which have not occurred when the statutes take effect, that is, which regulate the future, is a prospective statute. Retrospective statute. Every statute takes away or impairs vested rights acquired under the existing laws, or creates a new obligation onto a new duty, or attaches a new disability in respect of transactions or considerations already passed or deemed a retrospective or retroactive statute. Dilatory statute. A dilatory statute is generally affirmative in its terms, recommends a certain act or omission, but imposes no penalty on non-observance of its provisions. Mandatory statute. A mandatory statute is one which compels the performance of certain acts and directs that a certain thing must be done in a certain manner or a form. Classification with reference to objective. Enabling statute. This type of statute is which enlarges the common law where it is too strict or narrow. It is a statute which makes it lawful to do something which would not otherwise be lawful. Disabling statute. This type of statute restricts or cuts down the right existing at a common law. Permissive statute. This type of statute allows certain acts to be done without commanding that they be performed. Prohibitory statute. The type of statute which forbids the doing of certain things. Codifying statute. It presents an orderly and authoritative statement of the leading rules of law on a given subject, whether those rules are to be found in a statute or a common law. Consolidating statute. The purpose of consolidating statute is to present the whole body of statutory law on a subject in complete form, repeating the former statute. Curative or validating statute. It is passed to cure defects in the prior law and to validate legal proceedings, instruments, or acts of public and private administrative powers, which in the absence of such statutes would be void for want of conformity with existing legal requirements, but which would have been valid if the statute had so provided at the time of enacting. Repealing statute. A statute which either expressly or by necessary implication revokes or terminates another statute is a repealing statute. Amending statute. It is a statute which makes an addition to and operates to change the original law so as to effect an improvement or more. Parts of a statute. Title. The long title of a statute is an internal part of the statute and is admissible as an aid to its construction. Statute is headed by a long title and it gives the description about the object of the act. It begins with the word "an act to --". For example, the long title of the Criminal Procedure Code is "An Act to Consolidate and Amend the Law Relating to Criminal Procedure." In recent times, long titles have been used by the courts to interpret certain provisions of the statute. However, it is useful only to the extent of removing the ambiguity and confusion, and not a conclusive aid to interpret the provisions of a statute. In Re Kerala Education Bill, the Supreme Court held that the policy and purpose may be deduced from the long title in the preamble. In Manohar Lal versus State of Punjab, long title of the Act is relied on as a guide to decide the scope of the Act. Although the title is part of the Act, it is in itself not an enacting provision, and though useful in case of ambiguity of the enacting provisions, is ineffective to control their clear meaning. The short title of an Act is for the purpose of reference and for its identification. It ends with the year of passing of the Act, the Indian Penal Code 1860, the Indian Evidence Act 1872. The short title is generally given at the beginning of the words "This Act may be called --". For example, Section 1 of the Indian Evidence Act 72 says, "This Act may be called the Indian Evidence Act 1872. Even though short title is a part of the statute, it does not have any role in the interpretation of the provisions of an act. Preamble. Every act should have a preamble, which must express the scope, object, and purpose of the act. It is the key to open our mind to the makers, open to us the mind of makers of the law. It is accepted as an aid to construction of the act if the words of the statute are not clear. In Kashi Prasad versus State, the court held that even though the preamble cannot be used to defeat the enacting clauses of a statute, it can be treated as a key for interpretation of statutes. Headings and title of a chapter. Headings are of two kinds, one prefixed to a section, the other prefixed to a group or a set of sections. Heading is to be regarded as giving the key to the interpretation, and heading may be treated as preambles to the provision following them. In Kashinath versus State, it was held that the headings prefixed to sections cannot control the plain words of the provision. Only in case of ambiguity or a doubt, heading or subheading may be referred to as an aid in construing provision. In Durga Tatars versus Narayan Tatars, the court held the headings are like preamble which help a key to the mind of the legislature but do not control the substantive sections of enactment. Marginal notes. Marginal notes are the notes which are inserted at the side of the section in an act and express the effect of the section stated. Marginal notes append to the articles of constitutes have been held to constitute part of the constitution as passed by the Constituent Assembly, and therefore they have been made use of in construing the articles. In Wilker versus Goodwin, the court held that the side notes are not part of the act and hence marginal notes cannot be referred to. Definitional section and clause. The object of the definition is to avoid the necessity of frequent repetition in describing the subject matter to which the word or expression defined is intended to apply. A definition contained in the definition clause of a particular state should be used for the purpose of the act. Definition from any other statute cannot be borrowed and used ignoring the definition contained in the statute itself. Illustrations. Illustration is enactment provided by the legislature as a valuable aid to understanding real scope. In Maheshchandra Sharma versus Rajkumari Sharma, it was held that illustrations are part of the section and help to elucidate the principles of the section. Proviso. The normal function of a proviso is to accept and deal with a case which would otherwise fall within the general language of the main enactment, and its effect is confined to be on the case. There may be cases in which the language of the statute may be so clear that a proviso may be construed as a substantive clause, but whether a proviso is construed as restricting the main proviso or a substantive clause, it cannot be divorced from the provision to which it stands as a proviso. It must be construed harmoniously with the main enactment, CIT versus AJAC products. The normal function of the proviso to exception or stemming something out of an enacting clause or to qualify something enacted therein. Normally, it is not construed as nullifying the enactment or as taking away completely a right conferred by the enactment. A proviso, except as to cases dealt with by it, has no repercussion on the interpretation of the enacting part of the section so as to exclude something more by implication. It is construed in relation to the section or section to which it is applicable. While drafting a proviso to a section having more clauses, the draftsman must take care to see that the proviso is applicable to particular subsections and not generally unless the proviso is intended to apply to all subsections. This can happen if the proviso comes at the end of the clauses. But courts have held that a proviso sometimes contains substantive provisions which no doubt is not its function, and that in such case it is necessary to read it as a separate and independent provision. Case State of Orissa versus Devaki Devi. Explanation. An explanation may be added either to make clear the meaning of a definition or the scope of the provision, or to include or exclude certain matters from the meaning of certain words or from operation of a statute or section. It may also be declaratory to retrospectively clarify a doubtful point of law. An explanation to a statutory provision has to be read with the main provision to which it is added as an explanation. Explanation appended to a section or subsection becomes an integral part of it and has no independent existence apart from it. The purpose of the explanation is not to limit the scope of the main section. An explanation is quite different in the nature of a proviso. The latter excludes, accepts, and restricts, while the former explains, clarifies, and subtracts, or includes something by introducing legal fiction. Schedules. Schedules form part of a statute. They are at the end and contain minute details of working out the provisions or of express enactment. The express is a schedule cannot override the provisions of the express enactment. Schedules are added towards the end and their use is made to avoid the encumbering the body of the statutes of the matter of executive detail, or with the forms for working out the policy unveiling the section. Sometimes schedules contain transitory provisions. In the case of conflict between the body of the statute and the schedules, former is the body, will prevail. Former means body. Punctuation. Punctuation is a major element in the construction of a statute. Only when a statute is carefully punctuated, there is no doubt about its meaning can be given punctuation. It cannot, however, be regarded as a controlling element for determining the meaning of a statute. Applicability. Sometimes the statute is made applicable forthwith to certain provisions or classes of persons, or territory or goods, and it states that the government could, by notification gazette, extend its operation to other persons, class of persons or territories. Distinction between a proviso exception and a saving clause. A distinction exists between the proviso's wording proviso, exception, saving clause. An exception is intended to restrict the enactment clause to a particular case. A proviso is used to remove special cases from the general enactment and provide for them specially. Saving clause is to preserve some rights from the restriction of certain kind of rights, remedies, or privileges already existing. For example, saving clauses are entered into repealing clauses to safeguard rights which have already accrued during the operation of the statute, which is being now repealed. It is sometimes customary also to say that Section 6 of the General Clauses Act 1897 applies to save such rights or continues such liability notwithstanding the repeal. Transnational provision. Transitional provision. A statute sometimes contains transitional provisions which enact as how the statute will operate on the facts and circumstances existing on the date it comes into operation. It may also contain clauses intended to specify the provisions that may apply for the interregnum before the main provisions of the statute come into operation. Page number 29. Non-obstante clause, words without prejudice.